Okay, thank you so much again for joining us today for our webinar, Disability Support Pension, Eligibility, Challenges and Resources. My name's Carly Hanson. I'm one of the Sector Sustainability Coordinators here at Community Legal Centres Queensland. And before we get started, I'd like to firstly acknowledge the traditional owners of the land on which we're holding today's webinar. We're in Brisbane, at the Community Legal Centres Queensland office, and so I'd like to acknowledge the Turrbal and the Yagara people and pay my respects to their elders, past, present and future, and also acknowledge the very important role that Aboriginal and Torres Strait Islander people continue to play in our society. As today's webinar is being viewed by people throughout Queensland and across the country, I'd also like to extend my respects to the traditional owners of the land throughout Australia and welcome any First Nations people who are joining us today. So we're really pleased today to welcome Dermot Williams, community lawyer with the Social Security Rights Victoria's DSP Help project. Dermot will give an overview of the eligibility criteria and challenging claim and assessment processes in the disability support pension legislation. He'll also outline some of the common issues which applicants face when claiming DSP with a quick demonstration of DSP Help website at the end of the session. The DSP Help is an innovative, interactive online resource aimed at making the claim process much easier through the provision of clear and helpful information. So concerted policy advocacy regarding these issues has paid off with the recent announcement of a Senate committee inquiry into the purpose, intent and adequacy of the DSP. And we've got submissions closing actually very soon on the 25th of June. Dermot will provide a bit of an overview of the inquiry and the importance of the committee hearing client stories as well. So I will hand over to Dermot in just a moment and he can tell you a little bit more about himself at that time. But just firstly, some housekeeping. So today's webinar is being recorded and we'll have the recording available to download probably later this afternoon for everyone who's registered. The PowerPoints have been uploaded to our website and that they were emailed out yesterday afternoon, but you can also download them from the handout section of the GoToWebinar control panel in front of you today if you need. We'll hold questions over to close to the end. So there'll be a PowerPoint session first and we'll take some questions at that time before we go into the demo of the website, and we can do some more questions at the end. So do type them into the question box as you think of them so that we can put those to our presenter. The only other thing now I think is just to let you know that actually that's it. So I think I can hand over to Dermot now. Thank you so much, Dermot. Take it away.
Thanks, Carly. So yeah, as Carly said, we're going to be talking about the disability support pension, eligibility, challenges and resources with a quick demo of DSP Help. I do want to also mention that we have Linda Forbes here from Economic Justice Australia, and she's going to be jumping in with some comments about things as we go. Linda, did you quickly want to introduce yourself?
Yeah, my name's Linda Forbes and I'm the Law Reform and Policy Officer at Economic Justice Australia, which is the peak organisation for community legal centres around Australia that do social security law and are funded to do so. I just wanted to mention, Carly said that the submissions to the Disability Support Pension Senate inquiry that we'll be talking about a bit later close on the 25th of June. Most organisations are putting in applications for extension and we put one in and it only took 5 minutes to get an extension to the end of July. So while you're listening to Dermot, bear in mind that you do have time to put in a submission, even if it's just a one-pager talking about the difficulties for your clients. That would be fantastic, and otherwise get in contact with EJA about any issues that really are prominent in your service that you want us to convey to the inquiry. So thank you, and over to Dermot.
Thanks, Linda. So I do want to also quickly personally acknowledge the traditional owners of the lands on which we're meeting and pay respects to elders past, present and emerging, and any Aboriginal elders that may be here today. I also want to just give a quick thanks to Economic Justice Australia, who have helped set up this session, CLC's Queensland, and Carly, who's also helped set up this session, and everyone who's been involved in the DSP Help project. I won't list everyone who's been involved because there are quite a few people, but anyone who's listening in who has been involved, you're greatly appreciated. Just a little bit about us before we get started. I'm from Social Security Rights Victoria, or SSRV. We're the community legal centre, one of the community legal centres in Victoria doing social security work. There are a couple of others that do this sort of work as well. A bit about us: we specialise in social security law, policy and procedure. Our main thing is assisting vulnerable and disadvantaged Victorians to understand Centrelink and to challenge unfair decisions. We also work with others to do systemic work, highlight the issues of the laws, and we offer secondary consultation. So a big part of what we do is working with other professionals to upskill them, work with them in an integrated way, and to help them better help their clients. And part of that is obviously doing community legal education like we're doing today. Very quickly, we come at social security from a human rights perspective. We come at it from the perspective that having a social security safety net that is adequate and is working correctly is a human right. Okay, so getting stuck into the session, we've already sort of covered what we'll be doing, but just to be specific, we're going to be looking at DSP eligibility and challenges first. There will be an opportunity to answer any questions before we move on to the next bit. We'll then be looking at DSP Help, so it'll be a quick demo of our resource that we have available, how it works, what it does, and how you might be able to use it. Then we'll be talking a little bit about the systemic and policy activities that are happening at the moment, most notably the Senate inquiry and the review of the impairment tables. Okay, so disability support pension. To get the disability support pension, a person needs to have a physical, intellectual, or psychiatric condition that is permanent. They need to get 20 points on the impairment tables, and they need to have a continuing inability to work. Each of these points has some nuance to it, a lot of nuance to it, to be honest, and I'm going to be talking about each of those in turn. So we'll start talking about permanent conditions. A permanent condition, permanent doesn't mean permanent when we're talking about the DSP. A permanent condition is a condition that is fully diagnosed, fully treated, and fully stabilized. And again, each of those terms also has its own nuance. So fully diagnosed is a condition that has a diagnosis, that the doctors know what it is, and they've stated that in their reports. And that's really all there is to it. The questions to ask or things to look at is, has a diagnosis been made? Is any further investigation required? Things like referrals to have scans, like an MRI or a CAT scan or something like that. Things like referrals to other diagnostic procedures may mean that the condition is not considered fully diagnosed for the DSP. So it's worth considering those things when assessing whether someone might be fully diagnosed. Fully treated means that all reasonable treatment for the condition has been done. Basically when we're assessing this, we're looking at what treatment or rehabilitation has occurred and what treatment and rehabilitation is likely to occur or is going to occur within the next 2 years. So things like surgery, if that's something that's going to happen, and if they're on a wait list, that could mean that the person is not fully treated or the condition is not fully treated. Fully stabilized means that the condition is unlikely to improve, to result in significant functional improvement over the next 2 years. And the key question here is the improvement that they're likely to get going to be significant? Is it going to allow the person to work in the next 2 years? And the other important... If we could
just pop in here,
yeah,
Dermot.
Sure, Linda.
Yeah, Dermot and I spoke about me popping in from time to time just to point out where topics he's covering really are highly relevant to the Senate review of DSP. The big one here is the fully diagnosed, fully treated, fully stabilised. What we'll be proposing at the very least with the legislation is to get rid of the fully, because it creates problems. And I guess an example is where a person has recently been diagnosed with schizophrenia. 2 years ago, they were diagnosed with bipolar disorder, and before that, they were diagnosed with a personality disorder. Whatever the condition is, it's resistant to treatment, and the person is reluctant to take the antipsychotic drugs. In that situation, it could be said that the condition isn't fully diagnosed, isn't fully treated, isn't fully stabilised, but arguably it is. So people shouldn't put off putting in claims where it's very clear that they have limited capacity for work and that limited capacity is ongoing. So don't get too dissuaded by this fully, because it's kind of meaningless and people find it very difficult to understand what it actually means, including the Administrative Appeals Tribunal and including people's treating GPs and specialists.
Thanks, Linda. Yeah, 100% agree. We also see this with physical conditions as well. You may have someone who comes in and they might have chronic fatigue syndrome, and then later on the doctors say, or actually is there fibromyalgia here as an additional condition or a separate diagnosis, and that can cause problems for assessing this as fully diagnosed, fully treated, fully stabilized in a legal sense. But the key thing to remember is that this person obviously has a condition, they've obviously been receiving treatment, and in a lot of cases they might not be going to improve at all over the next 2 years. So arguably they should still be eligible for the DSP, and these are the challenges that they face. Talking a little bit more about the challenges, fully diagnosed, one of the challenges that we see people face is the formal requirements for a diagnosis. For example, in the assessment of an ABI, an acquired brain injury, you may need to have very specific diagnostic requirements. I've worked with a person who needed to get a neuropsychological assessment to get their ABI properly diagnosed. It was very clear from talking to this person that they were impaired significantly and severely by this condition, but they were living on JobSeeker. They couldn't afford to go and get a neuropsychological assessment, and that was a major barrier to getting the DSP, to having their condition considered fully diagnosed. Another one is mental health conditions. Table 5, which is the table which deals with mental health, which I'll be talking about in a little bit in more detail, has a specific requirement that your condition is diagnosed by a clinical psychologist or a psychiatrist, or you have evidence from one of those two people. Again, especially in the case of a psychiatrist, that's not something that is necessarily affordable for someone who has found themselves trying to access the DSP, is likely on JobSeeker, and is likely struggling to make ends meet. In terms of fully treated, the big challenge is understanding the legislation, to be honest. It is dense, it is complex for this particular point. To be fully treated, you don't have to have had every possible treatment that there is. You have to have had all reasonable treatment. What is reasonable treatment? It depends on the specific case and the specific circumstances. What is reasonable for one person might not be reasonable for another. It has to take into account things like, is the treatment accessible to the person? Is it close to where they live? Is it affordable? Is it risk? What is the risks versus the benefits? Does that calculation weigh up correctly? Other things to consider where we've had challenges is waiting lists. If someone is on a waiting list for surgery and they're likely to have surgery within the next 2 years, is that considered reasonable treatment that they have to have before they can get on the DSP? I would say that in a very legal sense, it probably is, because it's within that 2-year period that we're talking about for permanent conditions. If it's 4 years away, is that reasonable? I would say that that's not reasonable, because it's not within that 2-year period. They're unlikely to be able to access it within the sort of time frame that we're assessing. Even if it is within the 2-year period, is it guaranteed? If it's a kidney transplant, for example, yeah, the wait time might be on average 18 months, so it's less than 2 years, but you're still relying on a kidney becoming available that's compatible with you, which is in no way guaranteed. One further challenge that we've had, which unfortunately we haven't had success in arguing, is treatments that are inaccessible due to the recent COVID restrictions. we've had people tell us that they can't go and get the treatments that they need, that they've been recommended because of COVID. And we've run that argument that, you know, that treatment shouldn't be considered reasonable in those circumstances. And unfortunately, the tribunal hasn't accepted that when we've run that argument. So that's been disappointing, but it's an area of potential change. The last thing I'd like to talk about where fully treated is NDIS support. We have seen in one particular case, especially, Centrelink consider the supports that a person was getting through the NDIS to be treatment. They were able to access a psychiatrist, a psychologist, and a few other people through their NDIS plan. We argued that that is not treatment for the purposes of the DSP, because to get the NDIS, you already have to have a permanent condition. It's not. It's circular to then say that this is treatment that you need to have for the DSP. It doesn't make sense. It's also not guaranteed. You have to go through the intense application process for the NDIS, and something that isn't guaranteed we don't consider to be reasonable treatment. And fortunately, at this point, the AAT was very receptive to that line of reasoning. Fully stabilised is also challenging. It's about what the prognosis is and what the doctors and the medical practitioners and others are saying about the person's conditions going forward over the next 2 years. What we found is that doctors, and particularly for mental health conditions, psychiatrists, psychologists, etc., can be quite optimistic in their prognosis. They are hesitant, in my experience at least, to say this person is going to have this condition for the rest of their life or for at least the next 2 years, and it is not going to get better. Because obviously that's a very negative a very negative thing to say to a person, and especially in the case of mental health, that could actually exacerbate the mental health conditions themselves. It's arguably it's bad bedside manner is one way of looking at it. But when they when there is an optimistic prognosis in there, the decision maker can latch onto that and say, you know, look, your doctors are saying this is going to get better, you're not fully stabilized. So it is a catch-22 in many ways. One final point before we move on is just to generally note that cost is one of the biggest barriers to showing these things are satisfied. Accessing treatment can be expensive, and the majority of people that we see trying to access the DSP are living on JobSeeker. They cannot afford the treatments that they're expected to have. I will pause there. Linda, did you have anything to add?
Yeah, only that what you've outlined kind of fully exemplifies the issues about fully, you know, what NERDS fully means. And I guess with fully diagnosed, it's a question, and you gave the example of mental health conditions, that just because there's a question mark over the diagnosis that's causing the impairment, it doesn't mean that we can't argue that it's been fully diagnosed. Fully treated, again, some clients have difficulty, for example, where they have been treated for cancer. They've gone through radiotherapy and now they're going through a period of chemotherapy. Similar to what Dermot was saying, sometimes doctors are deliberately quite optimistic. So it's important to look behind that and perhaps question the doctor and encourage Centrelink to contact the doctor to have a conversation. At times we'll do that, particularly if a case reaches the authorised review officer level. Similar with fully stabilised. What we sometimes think is that fully stabilised means, and what Centrelink decision makers can believe, is that fully stabilised is this is the very best that the person can get given what the current treatment it is, but it's kind of more vague and you can be more creative about that. If a person, for example, is resistant to taking medication, again, the example of someone that's either got bipolar disorder or schizophrenia, is the condition stabilised to the extent possible given this particular individual and their history? And that's where it's important to get a really good treating doctor's report from the GP. That treating doctor's report doesn't necessarily mean referring the person back to the specialist and incurring that expense of going to a psychiatrist just to get a report to support the DSP claim, which flips out the medical professionals and can affect their relationship and their treatment relationship with the patient. That report can be prepared by the GP, but with the GP referring to specialist reports that they have had in the course of treating the person.
Yeah, thanks, Linda. Moving on to the impairment tables. As I said earlier, the next step once you have your condition or conditions considered permanent, fully diagnosed, treated and stabilised, is getting 20 points under the impairment tables. There are 15 tables currently, each dealing with a different functional area. So, for example, we have table 2 for upper limb function, arms and shoulders, table 3 for lower limb function, legs, feet, etc. We also have mental health function under table 5, which is quite an important one, table 7 for brain function, table 9 for intellectual function. It's important to note here that there is a difference between a condition and an impairment. This might seem obvious, but I think it's worth keeping in mind. The condition is the actual condition that a person has, so that might be diabetes. The impairment is how that impacts them, what they can and can't do. So that might be impacting them under table 1, functions requiring physical exertion and stamina. To give some examples of the impairment tables, we have table 3 here, lower limb function. To get 20 points, which is a severe functional impact, the person must be unable to do any of the following: walk around a shopping centre or supermarket without assistance, walk from a car park into a shopping centre or supermarket without assistance, stand up from a sitting position without assistance, and they must require assistance to use public transport. If anyone can work out what the difference between walking into a shopping centre and walking around a shopping centre is, I'd love to hear it, because I'm still yet to work it out. I would also point out this table does mention, in paragraph 2, that it includes a person who requires assistance to move around in or transfer to and from a wheelchair, or move around using walking aids such as sticks, crutches, walking frames, etc. The reason that I like to show this table is because the first bit has strangeness to me in that 2 of the things seem to be the same. The second bit doesn't seem to be required, it seems to just be clarifying, which actually makes it more confusing in a paradoxical way, because it's unclear how that second paragraph actually applies to people, and even the AAT has been unclear about this. The main point that I would make is that the challenges people face in getting the 20 points is not only that the requirements are so, in most cases, so high to get that 20-point rating, but it's just confusing, and it's confusing even to professionals, even to the decision makers themselves. Another example is table 5, mental health function. To get a severe rating for mental health function, the person has to have severe difficulties with most of the following. And there's the 6 factors that I've listed there. They each have examples. I haven't included all the examples, but the ones that don't have them do have them in the tables themselves, just to make this a little bit more readable. The examples that I've included there, I think, have some issues as well, or create challenges rather. So for self-care and independent living, the person needs regular support to live independently. That is, needs visits or assistance at least twice a week from a family member, friend, health worker or support worker. The challenge that I see and have seen with clients is people that need that level of support but are not getting it. They have an unmet need, and then demonstrating to the decision maker that that need exists when it is not being met. That can be quite challenging to have evidence that says this person needs people to come and see them at least twice a week when they're isolated and they're living by themselves because of their mental health condition. The other example I have there is the person's behaviour, thoughts and conversation are significantly and frequently disturbed to demonstrate severe functional difficulty with behaviour, planning and decision making. I just think that that is a very unhelpful example. What does frequently disturbed even mean? I've come to view that as frequently different to what you would expect, as in there is a disturbance in the behaviour, thoughts and conversation, but I think that that could be phrased so much better, so much more clearly to actually say what the impairment tables are looking for here.
And could I just point out too, Dermot, that it's only where a person has, for example, a family member or a community advocate that could kind of attest to that, that will be shown. If you've got a person, like you said, who's not having their needs met, who's not really participating in community life at all, or family life, very socially isolated, no one's going to be able to provide us a report attesting to that. And even their GP may be unaware of the extent to which they're isolated.
Yeah, definitely. And a lot of these factors, there's an interplay between them. So someone who's having severe difficulties with social, recreational activities and travel and interpersonal relationships, and I'd like to mention maybe they're experiencing agoraphobia, they're not actually going out at all. They might not have the connections to be getting that support for self-care and independent living. There's, everything interplays here, and mental health in particular is such a difficult area because, like you've mentioned earlier, Linda, the people themselves or the conditions may be resistant to treatment, or that the person might not have insight into their own conditions and may be unwilling to go through the treatment. And things like that. It's things that we do see in our own casework as well.
Yeah.
A quick note here, I did mention the difference between impairments and conditions, and the reason that it's important to keep this in mind is where you have multiple conditions or multiple impairments. So for clarity, where there's one condition that causes multiple impairments, each impairment should be given its own rating. Where you have multiple conditions causing a combined impairment, the impairment should be given a single impairment rating. So impairment ratings are given for impairments, not conditions. To give examples of that, one condition causing multiple impairments, classic example I use is diabetes. That could be causing problems with general fatigue. It could also be causing problems in both the lower and upper limbs. It could also be causing vision problems. Each of those impairments should be given its own rating. It should be assessed separately. For multiple conditions causing a combined impairment, you may have someone who has chronic fatigue syndrome, fibromyalgia, and asthma. They have 3 conditions, but they may all be impacting them only in terms of their stamina and exhaustion. So they only get one impairment rating for that, but it is the overall impairment that is being assessed. In terms of challenges, I've sort of mentioned these a little bit already. The biggest challenge is the opacity and the interpretation of the tables. It is a dense legislative instrument to grapple with. And if you're a person living with disability, well, at least the people we see who are living with disability engaging with this, they tend to find that very challenging. You almost need to be a professional or even a lawyer to fully grapple with what the tables are asking for. So yeah, that's a big challenge. As an example of that, I did mention in both of those table examples the word assistance. That has a very specific meaning in the tables. It means assistance from another person. So not assistance from like an aid, like a walking stick or a crutch. That wouldn't count as assistance. It means from another person.
Or a companion animal.
Yeah, or a companion animal, yeah. That's, although in the case of a companion animal, I haven't actually come across this, but just thinking out loud, a guide dog, I'm not sure where that would fit in terms of being an aid that they normally use, or whether it is assistance from another person. It's things like that where there are very specific interpretations that aren't necessarily the plain English common meaning of the words that you need to understand to fully grapple with what the tables are asking for. The other challenge, the biggest challenge we see, is gathering medical evidence in support of an impairment rating. So getting the evidence that shows that the person is impaired to the particular level that is appropriate for them. And that is, I would say, the biggest challenge for the DSP overall, at least in the work that we're doing, is getting the evidence to support overall DSP eligibility. I'll just quickly check in, Linda, did you have anything to add?
Only that I think you've made it really clear that it's the interaction of the impairment tables with the actual legislation, Section 94 of the Social Security Act, that provides for qualification for disability support pension, and then the assessment under the impairment tables. The interaction of the two is in itself quite problematic at times, and this is why we're making a big effort at EJA to do a really fulsome submission to the Disability Support Pension Senate inquiry, which is looking at all the legislation and the impairment tables, and then separately making detailed comments about each of the tables to the departmental inquiry that's going on at the same time, that's purely looking at the impairment tables, because the current impairment tables kind of sunset. So they're reviewing them, looking at particular issues with each of the tables. So the sort of stuff that Dermot was talking about with applying the tables for people with certain conditions, that's the kind of detail we'll get into when we're making the submission on the impairment tables, where our submission to the DSP Senate inquiry will be broader and rounder. But any of you out there, really feel free to make submissions with regard to either of those. But I would say really concentrate on the DSP inquiry, because it's truly broad and encompasses issues with the impairment tables, and encourage your clients to put in just one pages as well, just heartfelt letter to the Senate committee explaining how difficult it has been trying to get DSP, or the difficulties that they had, or from carers saying, you know, talking about from their point of view what the problems are. That would be really helpful.
Yeah, definitely. Thanks, Linda. The final requirement is to show that you have a continuing inability to work. What this means is that your impairment or impairments will prevent you from returning to work within the next 2 years. Again, there's nuance to everything with this. Work means work of at least 15 hours a week at minimum wage or better. I specifically mention at minimum wage or better because there are some kinds of work out there for people living with disability that are below minimum wage in supported environments. That kind of work, if they're able to do more than 15 hours of that, would not necessarily mean they are not meeting this requirement. Where the person does not have a quote unquote severe impairment, the person must also have participated in a program of support. Now, what I mean by severe impairment is 20 points under the impairment tables under a single table, rather than having, say, 10 points under one and 10 points under another. Program of support is a program completed through an employment service provider. So that's either a job active provider or a disability employment service. It might include things like looking for jobs or doing training. And it's important to note that medical exemptions from those programs will not count towards the 18 months that they need to do. So just to circle back a bit, because I realize I've missed a bit there, to show that you have participated in a program of support and met this requirement, you need to have participated for 18 months in the 3 years before applying for the DSP. There are some exemptions, which I'll cover in a moment. But yeah, that's the important thing. If you don't have the exemption, you need to have participated for 18 months, and you're only counting time when you're actively participating. So looking for work, going to the appointments that you're required to, usually while on job seeker, but it can be on a couple of other payments. It's important to note that there is nothing called a program of support. Most people, even when they're participating in them, don't realize that that's what the program of support is, because they'll be on job seeker or youth allowance, or in some cases parenting payment, and they'll be going to their appointments and looking for work and reporting each fortnight, and it's that is the program of support. I will just pause there. Linda, did you want to add anything? I think you had a note for this one.
Yeah, only that this is really a major issue with anyone out there from the Community Legal Centre or support services that's been trying to help people get onto DSP. This is a huge, huge issue. As Dermot pointed out, even people with very severe medical or psychiatric conditions, it's very hard to get 20 points on one table. It can even be hard for a person who uses a wheelchair or for a person who's struggled with severe psychiatric conditions such as schizophrenia for most of their adult life, and they're now in their 50s, so it can be really, really hard. So this is a huge issue. The problem is that catch-22, the more severely a person is affected by such a condition, the more likely they are to have periods of temporary exemption from mutual obligations if they're on job seeker payment, old New Start allowance. There are cases that we're aware of people that have been granted exemptions continuously, like a series of exemptions, sometimes for a few years, because the Centrelink staff understand, they grant the exemptions when the medical certificates are put in, because they understand that the person has very minimal, if any, capacity for work. And this means that they're really precluded from applying for DSP. And the other thing to point out, as Dermot mentioned, the program of support is a concept that really is only relevant for disability support pension qualification. So if a person, for example, who's been on Job Seeker New Start for years, is aware, has been told that there's this program of support requirement, maybe they've put in an application for DSP and it's been rejected and they've been told they don't meet the program of support requirement, they then talk to their employment service provider saying, I need to register for a program of support. Often that employment service provider doesn't really know what they're talking about, because it's a concept that's only relevant under the Social Security Act and becomes very circular. And I think, Dermot, you're going on to talk about exemptions and exits from program support.
I am about to talk about those. Just before I will point out that I think program of support is the biggest issue that I personally have with DSP.
Yes.
It doesn't even make sense mathematically to me. How a person with 20 points doesn't need to do this because they have that under one table, but a person with 90 points has to because they have 10 points under 9 different tables. How you could assume, or the system assumes, that that person with 90 points is somehow more able to, quote unquote, overcome the disabilities they're living with, that it just boggles my mind. It's the biggest issue with the DSP, at least for me personally.
Yeah.
To talk about the exemptions to the 18-month requirement, the first is having a severe impairment, having 20 points under a single impairment table. The next is people who are enrolled but are unable to improve their ability to find work because of their impairment. So if they're enrolled at the time they apply and the medical evidence they have suggests that it's not going to help them, they may not have to meet this requirement or may have been considered to satisfy this requirement. The other thing is that you can be exited from a program of support if the employment service provides you with a letter that says, we're terminating this program because we can't do anything to actually improve this person's ability to find work. There's essentially no point to them participating in this. It isn't going to help because of their impairments. The biggest problem that we have, or I've seen with that, is I've never seen one of these exit letters, and I'm not sure that many employment services even know that they can do that. Yeah, look, just to sort of, and I'm conscious of time, so just to sort of finish up talking about DSP eligibility, medical evidence is vital to the likely success of an application or an appeal. At the end of the day, that is what the decision maker will make their decision on. So having evidence that shows that the person is eligible and ideally addresses the DSP criteria directly is super important. If you can have a doctor or another person that is treating the applicant sit down, look at the DSP criteria and say, look, in my medical opinion, treating this person specifically, this is why they are fully diagnosed, fully treated and stabilized. This is the table they should have their impairment assessed under. This is how many points I would give for these reasons. This is their work capacity, how many hours they are likely to be able to do a week. And this is why a program of support is not going to help this person. That is the best thing that you can get to support an application. One quick note, and this is just a sort of a technical note, the qualification period. When assessing a DSP application, it is being assessed at the time a person applies and the 13 weeks following that. If you're making a new application, it's not that important to keep this in mind, as long as you've got medical evidence that is current and fresh and related to this period of time. It can become a challenge when we're talking about appeals, though. I've had one matter where the person applied, and by the time they got to the General Division of the Administrative Appeals Tribunal, it was 3 years later. To have the evidence, or to go and get new evidence to fill in gaps if there were gaps from 3 years ago, from what the person was experiencing 3 years ago, is incredibly challenging. It's not impossible. New evidence, as long as it is referable to the qualification period, can be considered. It is just very challenging to go back that far, though, and that is a big challenge that we see with people as well. I am, as I said, conscious of time. I know we've only got about 20 minutes left. So, Carly, I think we might just save questions for the very end, and I'll just quickly do the DSP Help demonstration now. So just bear with me while I change the screen share. So hopefully that's come up now. You should be able to see DSP Help. DSP Help is what we've come up with through our DSP Help project at SSRV. It is an online resource to help people and guide people through applying for the DSP or dealing with appeals. How we've structured this is basically putting all the information together about understanding the DSP, getting the right medical evidence. We have a medical evidence bot, which I'll talk about in a moment, applying for the DSP, and then what happens if the application is rejected. So we've basically tried to cover everything here. I won't go through everything here. It's essentially what we've been talking about anyway. But a person can be sent to DSP Help. They can read through this at their own pace. They are guided through questions that they may have. So I have a medical condition. Will I get the DSP? They get information about that. As they work through this, they will then be guided with where to go next. So if I just scroll to the bottom, what should I do next? Getting the right medical evidence. They can have a look at that page. Just quickly cutting to the medical evidence bot, and I'll quickly click start again because I've obviously been testing that. We do have a chat bot here. So the idea behind this chat bot is that a person can sit down in their own time, work through the questions that this bot asks them. So I won't go through the whole thing, but John Smith, what would you like to be called? John. And then it'll guide them through a conversation, basically. They'll have an opportunity to sit down, think about the impairments and the conditions they have, and write into the chatbot what they're experiencing, what they're having trouble with, why they want to get on the DSP, and what their day-to-day life is like. At the end, it will generate a medical evidence kit that they can either download or print off. And that is basically a letter that they can take to their doctors and say, look, I'm applying for the DSP. I really need your help because medical evidence is so important for this process to help me get onto this. I need you to write letters or reports or things that are going to help. The letter then gives information to the doctors, which is very similar to this getting the right medical evidence page, which takes the doctor through exactly what should be on the letter. So fully diagnosed, the doctor should state what the medical condition is, when it was diagnosed, who diagnosed it. Fully treated, we should talk about the treatment that's happened or is going to be planned or is planned for the next 2 years. We should talk about, the prognosis over the next 2 years, those kind of things. Other things about this, the DSP Help project is it's not just the website, it is linked to a wraparound legal service. So this is most relevant for people who are in Victoria, because obviously we're SSRV, we're Victorian based, but for people who cannot make use of this, this kind of assistance, they need something a little bit more hands-on, they can come to our legal service and we can give them advice. For people who, maybe try and use this and they get to a point where they're like, no, actually, I need help now, I need to talk to someone. We have the legal service that they can be referred into and we can assist them in that capacity. Yes, I did mention that this is aimed at Victoria, we being a Victorian legal service, and also this project has been funded by the Victorian Legal Services Board and Commissioner. So it does have a Victorian focus, but obviously this is Commonwealth legislation. The resources here are definitely available to be used by people right around Australia. So if you're not in Victoria, you are still most welcome to make use of DSP Help. And in terms of the branding and the logos and things, yeah, we are going to have SSRV on there, but we are considering some changes to make it more clear that it's available for people right around Australia. But we'll quickly change the share back to the PowerPoint. The last thing I just wanted to mention, and we've been speaking about this all throughout the session, is the systemic and policy activities that are happening at the moment, which is the Senate inquiry. That submissions for that are due 25th of June, but as we've mentioned, it looks like they're looking very favourably at people who are requesting extensions, so you may be able to get more time if you'd like to contribute to that. Also, the review of the DSP impairment tables, which submissions are due on the 31st of July. Before we have some questions, Linda, did you want to say anything else about any of that, and particularly those systemic activities?
Only that the two are intertwined, but like I said, it probably for people, particularly from generalist community legal centre that don't have specific expertise, legal expertise in DSP and the ridiculousness of the qualification criteria and the oddities in the impairment tables, you're probably best concentrating on the Senate inquiry. There are terms of reference that are on that web page. Economic justice is focusing on the first three terms of reference, but also there's, as always, there's a final term of reference, which is any related matters. And in that, we'll be particularly talking about people who are on job seeker that fail to qualify for DSP, but have significant disability, because probably there's more people with disability on job seeker than actually on DSP. It's a tricky thing, and a lot of that is because of the program of support requirement. You end up with people that are really quite severely impaired on job seeker and struggling with mutual obligations and incurring suspensions and sometimes non-payment penalties. That's what we'll be focusing on for any related matters, but otherwise we'll be focusing on all the issues that Dermot has so capably outlined.
Thanks, Linda. Carly, did you want to jump in and throw some questions at us? Are you okay to do that?
Hi, Dermot. Yes, and thank you to you and Linda for a great presentation and sharing the DSP Help website. Heaps of questions have come through, so we'll see how many we can get to, and they are quite long and complex. So I'll read them out as they come, and hopefully, Dermot, you can understand what they're about, because it's not my area of expertise.
Yeah, sure.
Firstly, just coming back to what Linda said, there was a comment that came through from Charlie mentioning exactly that they, have a client or a person that they're working with who is stuck on job seeker because they've been diagnosed with non-terminal cancer and need to undergo cancer treatment and recovery for 2 years, but don't meet the criteria. So that was just a comment that was relevant to what you mentioned just before.
Yeah.
So Kylie has asked that in relation to the examples that you've provided, doctors often feel constrained to just use the examples. Have you found that the tribunal will accept other examples provided by GPs as comparable to those provided in the tables?
In my experience, the tribunal is open to that, but it can sometimes take some argument, as in, I think that's in those particular cases where the doctors haven't addressed the examples directly, but there's comparable things there. I think there's that's where there's value in doing submissions for the tribunal, or being represented by a lawyer or by a support worker who can provide the tribunal with that clarification and clarity around that, and basically explain how what the doctors have said apply to the tables.
Excellent, thank you. A couple of questions have come through about the number of points from various tables, so I might try and combine a couple of those. So Ellie has asked if someone needs to get 20 points from one table or if it can be a combination of multiple tables.
So, sorry, keep going.
Oh, and I was just going to say, added to that, Sharon has asked, with the diabetes example, if the condition provides more than one impairment, does each impairment have to meet the 20 points? So those sort of complicated sort of calculations, I guess, around the tables and the points there.
Yeah, sure. So I think those questions might have come in before I had the slide on that, and that's
Very
fine.
possibly, yeah.
Just for clarity, you can have multiple conditions that lead to a single impairment. So basically, multiple conditions, they all affect you in your lower limbs. You only get one impairment rating taking into account everything on your lower limbs. You can have like one condition that leads to multiple impairments. So yeah, the diabetes example could affect your legs, your arms, your eyes, your general stamina, and maybe there's an argument that it has impacts on mental health as well, and makes your mental health conditions worse. Each of those impairments should be given its own rating. In either case, the overall impairment rating will need to be at least 20 points. If it's 20 under a single table, so 20 under table 5 for mental health, for example, that's great. Well, it's not great. It's sufficient for DSP, but you don't need to do a program of support. If you don't have 20 under a single table, let's say you have, in that diabetes example, 5 for your legs, 5 for your arms, 5 for your eyes, and 5 for general exhaustion, so 20 in total. That's when the program of support requirement comes in, and you also need to have participated in that, usually for 18 months within the 3 years before applying.
Yeah, and that's where doctors get very confused, quite rightly, thinking that even if they're aware of the tables and look at them, they think, oh, I can suggest that this person has points on 5 tables. They're a shoo-in for DSP, where in fact they're not. The doctor would be better off focusing on 1 or 2 tables and trying to argue that the points are at least 20 under one of those 2.
Yeah, definitely.
Great, thank you for clarifying that. Yeah, some of these questions did come in a little bit early, so potentially they've been answered, but it does seem very confusing. So
It is.
Jeff has commented that isn't the fact that each table has examples, doesn't that mean that they are guidelines, not mandatory? And what if one can show something similar? I think you may have answered that already.
I don't think I've got anything to add on that, but just very quickly, yeah, you're right. They are examples. So if it's something similar, you could make arguments, but I think that's where it's worth having someone to make the arguments.
So this question from Bryony, I'm not sure whether you can see the questions, Dermot, but this one's quite a lengthy one. So shall I just read it all out, and you can ask me if you need me to go back to the beginning. Bryony said, from the guidelines to table 1, the 20 and 30 point ratings in table 1 use the term assistance. Assistance means assistance from another person rather than any aids or equipment the person has and usually uses. And you can refer to 3.6.3.05E, use of aids, equipment and assistive technology. From the guidelines for table 1 to the tables for the 20 and 30 point ratings in table 1, use the term assistance. Oh, I think that might be the same thing copied twice, actually. Yes. So an assistance, it's really around, I think, whether an assistance animal would pass muster or not. I think you mentioned, you sort of discussed that a little earlier, Dermot, but if there was anything else that you wanted to add.
Nothing else I want to add, because what I will say is I haven't actually considered in any detail assistance animals myself. And when I mentioned it earlier, once Linda prompted me, I was really more thinking out loud. I think it's an interesting question though, and that's something that we could definitely look at, but it just hasn't been relevant to any of my casework. I am tempted to say that something like a guide dog for a person with a vision impairment though, it would be about, the question would be about what they can do with the guide dog, but I'm not 100%, so please don't take that as gospel right now. It's something that would need to be investigated a little bit further.
Sure.
And in fact, there's probably people who are in the audience who actually know the answer to that, that have experienced that issue specific.
For sure. Lots of very talented and experienced people here on the line. And I can see that Bryony actually has her hand up. Bryony, did you want me to unmute you, or are you able to unmute yourself if you wanted to clarify that question? No, she's popped her hand back down. So take that as answered. Thank you. So Kylie has mentioned that many people are doing programs, but they're not approved programs of support. And she's concerned where people do not have a modified program in place, and says you can't really complain about this, as it would mean it did not meet the definition of what is an approved program of support.
Sure. Was that was there a question in that? Was that just a comment?
No, I think that was maybe just a comment, but if you had anything to add, feel free.
Yeah, I mean, I think that's a valid concern. So there are rules about what is considered a program of support, and we've mentioned that most people doing it are on Job Seeker or another payment that has an activity test. One challenge that we said that I haven't mentioned is that you can volunteer to participate in a program if you don't have that requirement, but the program providers are reluctant to take people in for that. I'm not 100% sure of the reason for that reluctance. I have a feeling that there might be less or no financial incentive for them to do that, but I'm not 100% on that. In fact, Linda, that might be something that you know about.
I think you're right. I think it's the lack of financial incentive, which means it's a complete catch-22 for people that aren't on a Social Security Centrelink payment to meet the program support requirement. They'll never meet it, which is unfortunate. Usually there'd be a reason for that, such as partner income precludes them from getting their own Social Security entitlement, but partner income may disappear and the whole thing becomes problematic about the 3 years and the 18 months. And it's also the reason why a lot of employment service providers are very vague, if not obstructive, about exiting a person, because that's their bread and butter. They're funded to provide assistance to people in receipt of Centrelink payments. They don't really want the person to exit, and even though the individual worker that the client is dealing with the employment service provider, even though they might be quite sympathetic, they don't actually know what to do. And if a community legal centre rings the employment service provider, talks to the person's worker, often they're really stumped about what to do, and they end up saying, oh, they'll have to talk to Centrelink. We can only exit the person if Centrelink tells us to. And then the person goes to Centrelink and they say it's up to the employment service providers. Completely circular. And we coincidentally at EJA had a meeting with the Department of Employment and the Department of Social Services, senior people responsible for policy the other day. That meeting was an hour long, and those senior people were a little bit in the dark about processes as well, because the Centrelink Services Australia senior policy people weren't part of that meeting. That's fine, but really all those departments should be aware of this policy because it's so pivotal to DSP. They should have understood it. It was interesting that we could have an hour-long meeting during which some of the people participating in the meeting were actually Googling to try and get answers to the questions we were posing. And all due respect, if anyone out there is from those departments listening in on this, all due respect, it's a product of the complexity of the legislation and the policy guidelines, and that's why we really need to put a lot of effort into this DSP inquiry, because it's just not working. There's a lot of people that should be on DSP that are struggling on Job Seeker and other activity tested payments, exposed to mutual obligations on a lower rate, harsher income tests, and they are people with significant disability.
Yeah, definitely. I know we're at 12, Carly. I'm happy to stick around if people have more questions, though. I'm not on a timeline.
Great. There still are quite a few questions and comments here, so appreciate if anyone who's listening in needs to go. We are recording this, so you can always jump back into the recording if you've got an appointment or need to go to lunch. So we'll keep going for another maybe 10 minutes and see how we go with the questions. But if you've got more, then please do feel free to send them through. So Raisa has asked, once a person's application has been successful regarding the DSP, does Centrelink reassess that person every couple of years, or are they able to claim the DSP for the rest of their lives without any more assessments?
So the DSP doesn't have a time limit. So if they remain eligible, they will have it for potentially the rest of their life. They could, of course, at age pension age, swap to age pension, but they don't have to. Mm-hmm. It is reviewed, though. It's not reviewed every 2 years or anything like that. It's just that they could review it at any time to see if the person is still eligible. Obviously, when legislative change happens, reviews would then become a problem, particularly people who may have been on the DSP before 2011, I think, which I have to admit was before my time doing this kind of work. Yeah, people on the DSP before that time may have had an easier time getting on. And then when they've been reviewed after those changes and they're reviewed using the current legislative structure, they've then been found not to be eligible any longer and been kicked off. That is something that can happen.
Yeah. Kylie's asked whether you're going to look at the impact for prisoners with disabilities who lose the DSP and then have to try and navigate the process again after their release. Have you seen that that happening at all?
Yeah, that is an issue that we've seen. It comes up every now and then. People will come to us, particularly through our worker helpline at SSRV. Support workers will come to us and mention that issue. I think the biggest challenge that people in that scenario have is obviously if they've been in prison, they won't have been able to participate in a program of support. So if they do need to make another application, it's important to either have medical evidence that shows they have 20 points under a single table, or if that's not possible or accurate, participate in a program of support at least a bit so that they can show they've actively participated, and then pursue medical evidence that shows that it's not going to help, or get an exit letter from the program provider, which, as we've noted, both of those approaches are challenging.
Denise has also added that their DES services won't exit anyone. They've requested exit letters and been told that they will not do them. So it's disappointing.
It is. I think I have seen DES providers do it. So it's worth asking if you're assisting someone with that situation. But you're 100% right, Denise. It is very, very rare, and it's not the usual process that we see.
Emma's wondering if you've got any handy tips or hints for folks on JSP, I guess that's job seeker, who are trying to transition to DSP but can't afford the medical evidence required, as their healthcare providers will only do fee for service.
I wish I did. I wish I did have some handy tips. At the end of the day, it does come down to the medical evidence. When I've had people in that situation, I have said to them, look, you need to go to your GP probably, at least in the first instance, and you need to explain the situation, and you need to explain that the medical evidence is what is, in essence, going to gatekeep them from the DSP, and how much of a difference that could make to your life if you get the DSP. Our medical evidence kit does have some preamble information for the doctors, and it does highlight some of those issues and how key the medical evidence is. At the end of the day, with the current system, it just comes down to that's what's gatekeeping people from the DSP. But I would like to mention that overall, it's the system that is gatekeeping people. It's not the doctors doing anything malicious, of course. And if there was a way that we could restructure it so that those things are taken into account, that would be great. And I guess it's good news that we have some inquiries and things going on right now.
Yeah, one of the things we'll be proposing is that a treating doctor report, providing a treating doctor report on a standard pro forma issued by Centrelink Services Australia be a mandatory part of a person's claim for disability support pension. That's how it used to be, that a person, along with their claim form, had to submit a treating doctor's report. And that was a pro forma that addressed all the issues that needed to be addressed in order to establish whether the person qualified, and also was a starting point for assessing impairment. Doctors were up in arms about that because it's so time consuming. And so policy-wise, the departments went the other way, and those reports are no longer mandatory. What we'll be proposing in our submissions is that the treating doctor's report on a standard departmental pro forma again become mandatory. So if a person goes to their doctor and says, I've claimed DSP, I've got this form, the doctor has to complete it. And as a salve to the doctors, and quite reasonably, we'll be proposing that there be a new Medicare item number to cover doctors' completion of Commonwealth medical reports. And that's definitely what we'll be proposing. It's a sort of back to the future thing. It's the way it used to work, and it meant that a person's claim for disability support pension was much more likely to include all the evidence that was needed. It's one of the things we believe that has led to a decrease over the years in the number of successful DSP claims. And really that's what the government and the departments were aiming for, to put a lid on DSP grants, because the perception was that too many people were getting DSP. That's worked, but our argument is that it excludes and precludes the wrong people. It's many people with severe disability that belong to certain cohorts that can't get onto DSP. And I guess the pointy end of that is Aboriginal people in remote communities, very, very low rate of receipt of DSP, despite very high rates of disability and chronic ill health, and also high rates of dropping out of the social security system altogether because they can't meet mutual obligations for job search and other payments, job seeker and other payments, and also can't provide the sort of evidence that's needed for DSP.
Oliver has asked a question that which kind of follows on from that discussion around the GPs. So they're wondering if there's anything being done in Victoria to educate GPs on that issue, whereby they continue providing insufficient reports and patients are going through a cycle of collecting evidence that's causing them harm and distress.
It definitely is. The DSP Help project, so my project, is actually moving into its second, or is in its second year now. And the focus that we're having, so I should talk a little bit more about the project generally. I have demonstrated the website, but the process that we went through was a human-centered design process. So putting the human at the center of the problem-solving process and coming up with something that works for them. In the first year, we focused on DSP applicants, support and supporters, so friends, family, and professionals who may be supporting a DSP applicant. In the second year, we're focusing on medical practitioners, so doctors, psychiatrists, psychologists, specialists, anyone who could be giving the medical evidence themselves. And that's what we're trying to address now. So we're at the early stages of the actual design part of that process, so we're not sure what that's going to look like. It could be that DSP Help is modified in a way so that we have resources specifically aimed at doctors. It could be that we have a complementary resource. So to answer your overall question, Oliver, yeah, definitely that's something we're considering at the moment. It's basically the focus of what we're doing.
Excellent. Jeff has asked or mentioned that he's got a client who's not online or tech savvy and is wondering if there's any way for that person to get onto DSP Help or something similar.
Yeah, so look, if they're not tech savvy, if they can't get onto a website, then yeah, I mean, DSP Help might not be the right resource for them. If they're in Victoria, though, they're the kind of person that we'd love to speak to, because we are happy to, you know, give advice and potentially further legal services for people who the website isn't the best option for them, basically. And there are other resources from other organisations around as well. So I think most community legal centres that are doing work in this space will have a DSP fact sheet. I think EJA has its own fact sheet as well.
Yeah.
Great. I think Jeff mentioned that person was in New South Wales, so hopefully they can get onto some of the other resources that are out there. So Kylie's wondering if there's anyone you can complain to if the Disability Employment Service are refusing to exit a person, and who that might be.
Yeah, I think the first step that I would take is actually using Centrelink's complaints line and just see how that goes. But if you want to go outside Centrelink, I think it's the Department of, I forget which department it's called because they always change their names. I think it's DESE.
Yeah, DESE. Yeah, Department of Education. There's an employment. I always forget what this is.
Because I think it used to be jobs training and something, or is that a different department?
No, it's the same one.
Okay, so yeah, yep.
Yes, we can send out a link if you like.
Great. Yeah, happy to flick that around.
And also,
materials if you like, Linda.
it's really important too for these, if possible, to make a complaint to the Commonwealth Ombudsman, because it's only if they get complaints that they'll do what's called an own motion inquiry. We're talking to the Ombudsman about this, but we can get traction if they're getting individual complaints as well. So that's a really important step to take if possible.
One thing that we mention to our clients if they go through those channels, and we do encourage them to go through those channels first, but if they don't get anywhere with that and they're still not happy with how they've been treated, is to actually mention this to their federal member of parliament. Under the same sort of philosophy as you just mentioned there, Linda, it may not be that they can actually do anything practical for the person right now, but these are the kind of things that they need to be aware of. So raising it with them is definitely worthwhile.
Yeah.
Absolutely. Get them from all angles. So we're getting close to the end of the questions now. Thank you for sticking around, to those who haven't, and Janet and Linda for continuing to answer. UPEXCA has asked or mentioned that they've got a lot of patients at hospital with terminal illness, 1 to 5 years, going through chemo treatment to contain the tumour or cancer. Are they still eligible for terminal illness DSP? And secondly, if they do continue to work 8 to 10 hours a week, are they still eligible for the terminal illness DSP?
Yeah, so what I haven't really covered in this session, because it doesn't come up too often, but it's worth mentioning, is there are manifest grants for DSP, which I think is what the question is talking about. Basically, if you fall into one of a few categories, one in particular being you have a terminal illness and your life expectancy is less than 2 years, you can skip essentially the assessment process. The assessment process becomes about assessing whether you meet that criteria. Other categories that people can fall into is category 4, HIV and AIDS, intellectual disabilities where the person has, I think it's less than 70 for the IQ. There's a few other categories as well. So it's worth exploring that if you have someone who looks like they should obviously be on the DSP, whether they fall into one of those categories. So yes, to answer the first part of that question, that is definitely something that still exists. It's about showing that the life expectancy is less than 2 years. The second part of that question, working 8 to 10 hours, I don't imagine that that would be a problem because that's still less than the 15 hours work capacity for the continuing inability to work. With the caveat that the closer you get to working 15 hours, the more likely it is Centrelink is to look at it and say, hang on, are you actually, is this you working your maximum amount, or are you actually able to work a couple more hours putting you over? So someone working 14 hours is at risk of that happening. I don't believe someone working 8 hours is generally at risk of that happening. And someone working less than 8 hours, because that puts them in the lower category on the job capacity assessments. They normally do 0 to 7 hours and then 8 to 15. They shouldn't have problems with this.
Yeah, and something too that's worth mentioning, that some people, when they're finally granted DSP, can be really frightened of doing little bits of work, but there is a policy, and this is in the legislation as well, that if a person, while they're on DSP, starts full-time employment, their disability support pension can be suspended for up to 2 years. So if the person works for 6 months, full-time employment, and then decides that they can't cope or the work ceases, they should be their DSP should be reinstated on reclaim without a full assessment. It doesn't mean it won't be reviewed down the track, but it is reinstated. A lot of people are frightened of putting a big toe into working because they've gone through such an effort and trauma trying to get DSP, but that policy does still exist.
Yeah, just to add on to that, it's very important if people are going to do that to be upfront with Centrelink about it. The suspension only applies if you report correctly, you tell them about the change of circumstances, whereas if you don't, they will actually cancel the payment. So the risk is not attempting to work, the risk is not telling Centrelink that you're attempting to work.
Right.
Great, thank you. Sushma has asked whether it's recommended to specify the exact points in the medical evidence. I think that might be.
I think it.
Yeah.
Yeah, I think that it is, as long as the evidence is showing why the medical practitioner is giving that rating. One thing that we run into with I want to say poor quality medical evidence is where someone's had a crack at looking at the tables and assigning a rating, but they've just said this person should have 5 points under table 1, 10 points under table 2, and 5 points under table 3. They haven't then said, because this person is having severe difficulties or moderate difficulties with XYZ from the actual impairment tables, it's important that they link, or the evidence links, the rating that is being given to the criteria that in those tables, so that the decision maker can see why, basically.
Okay, last question from Oliver. So, what do you make of this hybrid version of half pension, which is something apparently the community refers to it as, whereby some recipients on New Start are obtaining a pension card but are on NSA, assuming they are half pension, as they've not been able to get DSP. I hope you got all those acronyms.
I think that's an interesting point to raise. I think the issue there is people that have a partial capacity to work who find themselves on job seeker. And I think that to expand on that, the biggest issue is people that are on an inappropriate payment for them. So people that are on job seeker when they should be on the DSP. I don't really have any comments about them getting a pension card or anything like that. I think that is what it is, basically. But I think this question does highlight this issue of people being on the wrong payment, and that is a consequence of the structure of the DSP at the moment, unfortunately.
All right. That's all the questions that have come through. I've got a couple of people with their hands up. I'm just going to double check that they didn't want to ask a question verbally. Tim, you've got your hand up. Did you want to ask a question, or that's just your hand up from earlier? If you do want to ask a question, just unmute yourself, or I can unmute you and you can speak. Okay, nothing. And Ruler, same situation. You've got your hand up. Did you want to ask a question? I'm happy to unmute you if you've got a microphone. All right, I'm just going to take those as no's for the moment unless I hear otherwise. On that note, I will close out the session today, and thank you very much to our no questions, great. Thank you so much to our presenters for your time, and particularly for responding to all of those great questions that came through. It's obviously a very complex area and causing a lot of confusion for advocates and lawyers and others who are trying to assist clients in this to get the DSP. If, Linda, you could send around that link that you mentioned earlier, I'll be able to forward that out with the materials together with a copy of the recording for today's session, which I can do this afternoon for all of you. But for now, thank you again on behalf of everyone who joined us today, to Dermot and Linda for presenting. And I'll just give a quick reminder to finish up by completing the short feedback survey that will appear once I close this session. So thanks again, and we'll see you next time.
Thanks, Callie. Thanks, Linda.
Thank you. Bye, everyone.
Bye.